This is the life cycle of a regulation, sort of a step-by-step step instruction how a regulation gets adopted and becomes effective in the California rulemaking process. First, to understand are the rulemaking bodies. To begin, California has over 200 state agencies, departments, boards, commissions, and bureaus, which we collectively refer to as rulemaking bodies, rulemaking agencies, rulemaking entities. They all make public policy through their authority to act in a quasi-legislative fashion. That is their authority to adopt regulations. A list of those state entities that adopt regulations can be found on the website of California's Office of Administrative Law, OAL. It's found at the website www.oal.ca.gov. What can a regulation do? A regulation can be added, amended, or repealed. And regulations are found in the California Code of Regulations, the CCR, which is organized under various subject matter titles, of which there are 28 of them. And these titles contain over 60,000 state regulations currently in effect. What are pre-rulemaking activities? Well, some rulemaking bodies or entities engaged in an interested parties process or an informal process, sometimes referred to as pre-rulemaking, in which that regulatory entity solicits or brings together the regulated community or other interested parties. The parties can meet with state agency staff prior to a formal regulatory project commencing to provide input before the agency staff begins drafting any regulatory changes. Many agencies and departments utilize this interested parties process to review proposed rulemaking projects prior to commencement of that formal process. These pre-rulemaking activities sometimes are brief and sometimes are quite lengthy in time. Some meetings are used to simply solicit feedback, but in other meetings, they're used to write and negotiate regulatory language, again, before that formal rulemaking process, the formal APA process begins. The rulemaking laws. California's Administrative Procedure Act, APA, contains required procedures for rulemaking and administrative hearings under OAH, the Office of Administrative Hearings. The APA is found at chapters 3.5, 4, and 5, commencing with section 11340 of the California Government Code. And these are in part 1 of Division 3 of Title 2 of the Government Code. In addition, there are a number of regulations governing the APA process. They're found at the Code of California Regulations, CCR Title 1, Sections 1 through 120. OAL's website also includes a number of checklists used by OAL to review regulations, as well as their excellent publications, including California Rulemaking Law under the Administrative Procedure Act. Public notice. Every rulemaking body is required to annually adopt a rulemaking calendar that's published on their website. These rulemaking bodies establish interested parties' mailing lists for notices of rulemaking activities by that agency or department. The development of the regulatory package. The rulemaking body develops 4 required documents during the preliminary activity stage, which are needed to formally initiate the rulemaking process. First, the express terms of the proposed regulation, that is, the proposed text. Second, the initial statement of reasons, known by its acronym ISOR or ISOR. Third, the fiscal impact statement. And fourth, the notice of proposed rulemaking. Initial filing of the package. These 4 initial documents, the ISOR, are initially filed with the OAL and published by the agency or rulemaking body. Then begins the formal rulemaking comment period. The 45-day opportunity to submit written, faxed, or email comments on all or any part of a proposed rulemaking when the notice of proposed rulemaking is published in the California Regulatory Notice Register. The notice of proposed rulemaking is also mailed to interested parties and posted on the rulemaking agency's website. The public hearing. Under the APA, an agency has an option as to whether it wishes to hold a public hearing on proposed rulemaking. However, if an agency does not schedule a public hearing and any interested person submits a written request for one within 15 days prior to the close of that written comment period, then the agency is required to hold a public hearing. Because of this requirement, an agency usually schedules a public hearing at the outset. Then agency consideration of submissions. The APA requires the rulemaking entity to consider all relevant information presented to it during the comment period before adopting, amending, or repealing a regulation. After that initial public comment period, the agency will often decide to change its initial proposal, either in response to public comments or on its own. A rulemaking agency must summarize and respond on the record to timely filed comments. The summary and the response to comments must demonstrate that the agency has considered all relevant material presented to it before adopting, amending, or repealing the regulation. And an agency may respond to a comment in one of two ways. Now, according to OAL, the agency must either explain how it has amended the proposal to accommodate the comment, or two, to explain the reason or reasons for making no change to the proposal. An agency's summary and response to comments are included as part of the final statement of reasons, FSOR. Further public notice. Before a rulemaking agency adopts regulatory changes, it has to mail a notice of opportunity to comment on those proposed regulatory changes, along with a copy of the text with the proposed changes to each person who has submitted written comments on the proposal or has testified at the public hearing or who is asked to receive a notice of proposed modifications. The agency also has to post this notice on its website. Transmission of the package to OAL. Thereafter, the agency must transmit its rulemaking file, called the FSOR, Final Statement of Reasons, to the Office of Administrative Law, and OAL must receive it within a year from the date that the notice of proposed rulemaking was first published in the California Regulatory Notice Register. OAL then has 30 days, working days that is, not calendar, in which to review the rulemaking record to determine whether it demonstrates that the rulemaking agency satisfied the procedural requirements contained in the APA. Review by the OAL. OAL reviews the rulemaking file for compliance with 6 statutory standards of review. They are authority, reference, consistency, clarity, non-duplication, and necessity. OAL may not substitute its judgment for that of the rulemaking agency with regard to the substantive content of the regulations. Actions by OAL. OAL can approve the regulation, in which case it's transmitted to the Secretary of State's office, and it takes effect at the beginning of the following calendar quarter. After transmitting approved regulations to the Secretary of State, the regulatory changes are published in the California Code of Regulations. If not approved, deemed a regulatory disapproval, then OAL issues a written decision detailing why the proposed regulation failed to meet the legal or procedural standards set forth in California's APA. And after OAL review occurs, even after the agency or department has completed the rulemaking process, there are opportunities to be involved, such as with OAL review, including appeal to the governor's office, or even challenging the rulemaking in a court of law.